have you both had an opportunity to review that report?
We have, Your Honor.
The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense.
Not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering.
Any other evidence or witnesses?
So just brief argument, if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor, just like.
Mr. Rojas, you may make argument first.
Thank
Go
you,
ahead.
Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. And what we're here asking for this morning, Judge, is probation. Mr. Fontes, he is a young offender. I know the court is tired of hearing the same story over and over, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontes that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer. Because there'd be one less guy running around with a gun when he does get out of. Before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all that stuff's fine, but you, Judge, where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you send this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're going to pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. State's attorneys were recommending youthful offenders, probation, let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that the underlying offense is evading arrest or detention with the use of a vehicle. And then we've got 26 DCCR 0631, a new offense of evading arrest or detention with the use of a vehicle. And what is the announcement?
I reviewed the discovery in this case and discussed it with Mr. Guillory. He's advised that he did not commit the new offense, although the state's conveyed what I consider to be a reasonable offer to dispose of the NTRP in the new case. Since Mr. Guillory is maintaining that he's innocent in the new charge, I have to set it for him.
So I would,
Absolutely not true.
so we want to go through the motion then and go forward on that motion instead of the, let me get that pulled up. And are there any videos or anything that you need some time to watch?
No, I don't think
before?
for reading the file, there were some videos that identify the defendant. Or actually identify the person operating the motor vehicle.
Oh, okay. All right. Give me just a second to get that pulled up.
I do have some media on that, Judge, and I'll make sure that Mr. Kimler, if he indicates to the court that he is retained on that case, I will make sure he has access to discovery, and I'll make a copy of that.
I've got them on both cases.
Okay.
So if you'll make that request, Mr. Kimler, it sounds like there might be something that,
And also, Judge, at the appropriate time, if I might just ask the court some questions regarding the bond issues, I'd appreciate that.
Mr. Guillory, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down, and will he waive the formal reading of the motion?
You will.
All right, Mr. Guillory, in clause number 23, DCCR 1225, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, February 27th of 2026. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Not true, because
It's okay. I'll get the explanations later. I just need to know true or not true.
yes,
Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, February 7th of 2026. And is that true or not true? Count 4 alleges that you failed to provide and maintain an accurate residence address with probation officer. It says you reported your address at 2218 Rush Street, but identified your address at 2450 West Lucas to the Beaumont Police. Is that true or not true?
that's not true because I had to change.
All right. Did you tell probation?
Yes, ma'am.
Okay. Count 5 alleges that you failed to provide documentation verifying the source and amount of your income, 2025 tax returns, etc. Is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing community service hours as required. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 11:20 p.m. on February 27th of 2026 in violation of your curfew. Is that true or not true?
Was bad.
February 27th of 2026.
It's not true.
Not true.
Okay. Count 8 alleges that you are behind in your court assessed fees as of April 20th of 2026 in the amount of $1,812. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 3, 5, and 8 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 3, 5, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke the probation, but I'm not going to do that. I'm going to recite the case for a hearing, and any discovery or any issues with regard to that new case get taken care of before then. And Ms. Malfino, do you anticipate that being, I guess, just one officer?
One officer and Miss Lopez.
All right, so we can just do it at 11, don't y'all
Yes.
think? No, just on a regular court date, but at 11, giving us about an hour. Okay. All right, we'll see you back then, and we'll get an updated pre-sentence report as well. All right,
So,
we need a fingerprint over here, please. Oh, wait,
I
is there
actually-
something else? I'm sorry.
No,
Come
I
back.
just was gonna let you know, I actually have one of those officers coming for a motion to suppress next week. I don't know if that will give Mr.
That's fine. You can do
time,
it.
but I'd be happy to do it. It's next Monday, the 13th at 1. We have a couple of those type of hearings.
That's fine.
I don't know that I can get an updated,
Okay, I just wanted to offer.
okay,
Same officer would be here.
it would be, okay, as the 1 o'clock. Let me look at that and make a notation on that, and I'll take a look at it after we get.